Hello everyone, welcome back to our little conversation about wills, trusts, and more. And of course we have Eileen, Kerlin, Walsh. Thank you for coming back, Eileen. I want to congratulate you on the great job again that you have been doing, bringing some guests and on your show. It is really interesting. Thank you again for bringing that to Channel 4.
Thank you. My pleasure.
Today we're going to be talking about reviewing living trusts, and I'm going to turn this over to Eileen to kind of give us a basic steps of what this is all about, and maybe enhance some of your thinking about yourself and how you could use these steps for your own personal use.
Lovely, Ron. We'll start talking about the basic trust. What is it? What does that mean? And a good way to understand what a trust is just a way to hold title. We all know that we can have a bank account individually in our names. We could have it in joint tenancy with our spouse or with another family member or a trusted friend. We can also hold title in trust. So it's a way to hold title that comes with benefits. I also like to describe a trust as a treasure chest. So if a client is wondering, if I get a trust, what does it mean? Well, we're just going to use it as a treasure chest to pull all your assets together. We'll retitle those accounts. We'll put your home in there that you have equity in, any investment properties, LLC interests, some corporation shares. All of it we can put in the treasure chest. And then the terms of the trust, the agreement, is where we determine who will get what and in a way that you decide, as well as how we'll take care of you in your lifetime if you become incapacitated. So it's this wonderful treasure chest, it's an agreement, and it is a way to hold title.
Now, I don't know if you covered it or not, but did you say financial accounts as well?
Yes. When we create a living trust, we can retitle just about everything we own in the trust. And when we start off with the trust, there's a lot of retitling. So our checking our savings if we want to. Sometimes we don't. Sometimes we'll just make the trust a payable on death. But we can retitle assets. We can make the trust the owner of our stocks and shares. We can make the trust the beneficiary of our insurance. But for a trust to work really well, we've got to go through those accounts and make sure the trust is reflected and that the trust is in the treasure chest to make sure that it works. Because one of the dangers, or maybe that's a little strong of a word, but I've often seen clients come to me with trusts already drafted where this essential second step wasn't taken. So we want to make sure when we create the treasure chest that it does get filled, because that's how we make sure that your assets go the way you intend, because they must be reflected in the trust in the first place in order for the trust to have meaning.
Now, would you say that a trust is a tool for the wealthy only?
Certainly trusts are used by those who are wealthy to minimize taxes for their family, for death taxes, income tax, but by no means are they a tool for the rich. In fact, the more modest the estate, when parents are concerned with maybe they don't have as much as they would like to leave their children or their grandchildren, a trust is a way straight up to avoid the cost of probate. I mean, 10, 15,000 can go in attorney's costs, executor costs, filing fees, publication, that we can preserve for the family by making a small investment now in a trust. We can also protect what you're giving to your children from divorcing spouses, creditors, that sort of thing. So whether it's a very large estate or a modest estate, a trust is accessible to everyone. We use them a lot here in Illinois. This is an inexpensive state to get involved in trust. We may have said before, Florida and New York, the other two big trust states, it's an expensive world to become part of, but in Illinois, it's very inexpensive. They're widely used, easily accessible, and a tool for everyone.
Is there a common trust that's used for our community?
Yes, Ron, because I specialize in trust, concentrate in that area, I do many trusts, and we've talked about a lot of them on the show. But overwhelmingly, the revocable living trust is the most common for our community. I would say over 90% of those in our community who come forward to do some trust planning are well served by a revocable living trust, even a joint living trust. So sometimes when we have particular asset issues or family issues or very large estates where we have to do tax planning, we do a trust for husband and wife, but for many couples who are not yet taxable, a joint trust, which is a lot like their joint bank account or holding their home in joint tenancy, will do the trick. We get the funding done, and then all these wonderful tools that we have within the trust to help them and their family can work for them. So the revocable living trust, very, very common trust used by a large percent of our community.
Well, isn't that a tool more for death taxes too?
Well, death taxes, when I first started practicing 16, 17 years ago, death taxes were a huge issue because we were at 650,000. You couldn't leave more than that and all your assets combined to your family without paying death taxes. So we really had to use the trust to split the asset, double the exemption. That was a big part of the practice. Now, luckily, it's not such a big issue because you can leave up to 4 or 5 million. Now, if you're in the 3% of our community that does have those kind of assets, we still use trust planning to save hundreds of thousands of dollars. But even if you're not death taxable, there's still lots we can do to prevent the loss of income upon the children receiving the benefits. So there are tax consequences, there are tax savings. Luckily, inheritance, death taxes are not near as big an issue for we estate planners or for the community as they once were.
Well, is that a variable by state? Does it change by state? It does.
Yes. Federally, of course, it's the one standard everywhere, and that's $5 million, over $5 million now. And it's automatically doubled for a couple. So federally, unless we have assets in excess of 10 million, we really don't have that planning to do. But for each state now then has their own standard for the state taxes. A lot of states used to just piggyback on the federal. If you were taxable federally, you were taxable state-wise. But now that it's so high federally, some of the states don't like that. Illinois, for the first time in 2012, deviated from the federal standard. So now it's different. So if you have 4 million between the couple, you're suddenly taxable under Illinois, and it is not automatically doubled. So yes, we always have to take the state consideration as well as the federal taxes into consideration. And Illinois has deviated from the federal standard, so when we have large estates, that's a huge issue now that wasn't before, and we really need to take it into consideration. And because Illinois doesn't have what we call portability, that automatic doubling of the exemption for husband and wife, we really have to plan within the trust upon the death of the first of them that we can make that doubling happen. So that truly is saving hundreds of thousands, but that's for our larger estates. And yes, it does vary from state to state, and something that estate planners have to take into consideration.
Yeah, okay, so if someone is in Illinois that's an estate planner, they have to think about and consider the client or the state that they're living in.
Oh, absolutely.
That's what they have to comply with.
Absolutely,
okay.
Absolutely.
Now, does this tool also protect from creditors?
Well, the one thing I always tell my clients when they're considering trusts is this, the revocable living trust, that very typical trust we talked about, is not an asset protection trust. And there is a perception in the community that if you get your assets in trust suddenly, you know, it's Fort Knox, it's protected from creditors, bankruptcy, that sort of thing. The revocable living trust is not that kind of a trust. There are asset protection trusts used very, very cautiously. My estate planning philosophy is that my clients' assets are for them for their lifetime. Now, if you give up some of your assets to protect them from creditors, protect them from Medicaid spend down, you give up access to it yourself. You can still get some income from it, but ultimately you've preserved it for your children from the government taking it, but you've given up a lot of your own access to it. Now, if we have larger estates where we can set aside a portion, we're certainly going to do that. But if we don't know how much our clients are going to need for their lifetime, I'm not going to look at their estate to see how I can preserve it for the children, not knowing what they'll need for their lifetime. And most clients do agree with that. So that's the consideration there.
Could you walk very specifically through the advantages of a living trust?
They are legion when you get a living trust in place, and there's advantages for your lifetime and for after death. For lifetime, if we get this trust in place and we get it funded, we can avoid guardianship. So we talk a lot about probate and the cost of it after death, But guardianship, which is probate during lifetime, if you become incompetent and no one has been designated to take care of your assets for you, then we have this very expensive, invasive court involvement in your assets. You avoid all that with your lifetime. If you become incapacitated, or even if you just get to the point, some of our clients are elderly and they've done it long enough, they're ready for a break now. They can let the children take over, or whomever their trustee is, see what kind of a job they're doing in running the assets, and make sure that that's the person they want taking care of matters after they become incapacitated or even after death. So during lifetime, the management of the assets. Then after death, there are so many advantages. One, we stay out of the courts. We don't have this portion of frozen time where even with beneficiary designations, it takes time to get to the asset. So we have a trust account, the successor trustee steps right up, pays for the arrangements. There's no frozen time where bills can't get paid or no one can access money. We don't have to wait for the courts to distribute. We don't have to wait for the courts to approve the administrator. There are so many ways that we can skip the public nature of it, skip the publication. Disgruntled heirs coming from behind. There's no court to go to. Creditors, we don't just publish in the paper, here's an estate open, come on in, the water's lovely. Many advantages for the smooth, efficient, private transfer of the estate. And then we just get to the advantages for the family or for the beneficiary. We can then protect them with general needs trusts from creditors, predators, divorcing spouses. Our clients want their money to go to their children, not divorcing spouses. We can take care of someone with special needs. If there's vulnerabilities, maybe some sort of addictions or mental or physical incapacity, we can use general needs trusts. We can take care of children, grandchildren with grandchildren's trusts. So the trusts that we structure within the living trust to take care of whomever you're leaving your assets to. So not only do we stay out of the courts and make it a lot less expensive, we really protect that money for the children and beyond. There are multiple reasons for getting the trust in place, getting it funded, know who you're appointing as the successor trustee, keep it updated, and really you've just done a tremendous benefit for yourself and your family. And the peace of mind. One of the things I love about my practice is that when clients have this all taken care of, they're just beaming. They feel so proud of themselves. Tremendous peace of mind that they have been so responsible, grown-up adult, totally taking care of their affairs. It's the ultimate act of fiscal responsibility and ultimate gifting to yourself and to your family by getting this all taken care of.
I want to back up a little bit, and I'm going to anticipate a viewer having this question, and I'm sure there's people out there saying, well, if I put a trust and I get this all started, and I have a disgruntled family member that I'm going to have as part of the heir into this trust, to be a beneficiary or whatever you want to call it. The point I'm trying to ask is, does the trust protect that individual from suing or contesting?
Oh, very, very good point. Our trust will always say that if someone is getting a portion and they sue to contest their designation, that they'll get nothing. And often,
excellent.
Often that is enough to stop them right there,
Yes.
because if they sue unsuccessfully, they'll get nothing. Beneficiaries
But what if it wasn't in there? What if that paragraph and that wording, that language was not in there?
Well, then they could sue to see what they could do to try to get more, but they'll probably be unsuccessful, and then ultimately they would get the share they were originally unhappy with, which is why we always use that contesting language. But Ron, when a trust is correctly drafted, the truth is it's very, very hard for an unhappy beneficiary to come forward and say anything. One, there is no court, because there's no probate. So if they're unhappy, they're going to have to go find an attorney who agrees that there's some reason that they have a cause of action, having looked at the document, start their own legal proceeding, whether it be some breach of duty of the trustee. But if the trustee is doing exactly what the trust tells them to, this was properly drafted, properly witnessed and notarized, there's really very little a non-happy beneficiary can do. And that is how it should be, because this trust reflects the trust maker's intentions, and they ought to have legal effect. Just because we're staying out of the court doesn't mean that it's somehow less legally effective. If anything, it's more so, because it's much, much harder to contest. You have to get your own legal proceeding in place, convince a legal office that you have some cause of action, and then fund it yourself, because there's no executor funds, there's no estate for the money to come from. So we do find that if we ever have any action, it's maybe that a trustee hasn't complied with the terms, maybe hasn't given as much information to the beneficiary as they should, because even though the beneficiaries don't have a lot of power when it comes to the administration of the trust, we do want to make sure they get their share, they get it in a timely manner, and they are informed of the trust assets and what their share means. And we will always tell our clients and our trustees, make sure that you keep the beneficiaries informed, because often when we have unhappy or impatient beneficiaries, it's because they're getting no information. If they're getting timely reports, and we don't put too much of a benefit, not too much of a burden on the trustee, because they have a lot of work to do. They're the ones doing all the paperwork, getting everything distributed. But we do want them to, at least annually, let the beneficiaries know what's going on, what the assets are, what their distribution will be. If we have, say, a lot of tax issues that we need some time to sort out, and we always tell our trustees, don't pay out too much if you know someday you're going to have to ask for it back. But perhaps a partial distribution will keep beneficiaries happy, while we keep enough to make sure that any tax bills or any bills coming in or any claims are taken care of. So well managed, the trust usually does keep the beneficiaries happy. And an unhappy beneficiary with their share, or it's often the distribution terms that beneficiaries don't like. So perhaps dad thought, well, I know the son might just blow everything, and has some protections in there. The son is maybe likely, because of the nature the father was hoping to protect against, comes in and wants to get the trust broken, wants to get the terms modified and properly drafted. That's just not going to happen. So those are the actions where that are likely to happen, but we don't like our share, we want this trust broken, properly drafted. That's just not going to happen. And that's a comfort for the parent who's setting it up this way, because that's what they want.
That's what's going to happen, just exactly the way they document it. The next big question is, when should one create a trust?
Oh boy, the answer is always now, isn't it, Ron? When you're youngest, young or old, rich or poor, whatever stage in your life you are at, you can benefit from a trust. What's the reality? As our clients get older, as they contemplate in retirement, as they accumulate their assets, they're much more likely to do a revocable living trust, because they're now starting to think about what if they became ill or became incapacitated, or how are they going to distribute their assets after death. So while everyone can benefit, everyone gets the peace of mind, the reality is, as we grow older, accumulate our assets, either contemplate retirement or are already in retirement and are just planning for the day when it comes, a trust is a great idea. But when you're most competent, of course, is the best time, because we do have those statistics where 1 in 3 of us will have a period of incapacity prior to death. It's just too late. It's just too late. And we have had times in our office where, with the family bring in the parent, and we know it's too late. They're just at the point that they can't make those competent decisions anymore. And that's really heartbreaking, because you have these children who really want to take care of the parent, need now those powers of attorney, finance and health care to take care of them, know that the parent didn't want them ending up a year in court and spending a lot of the money in probate. But if it's too late, it's too late. And there's no getting around the fact that they no longer have the capacity to sign the documents. So never underestimate the power of your healthy mind. Ron, one thing that I have learned from estate planning is the frailty of humanity. When you're young and healthy, you can't even imagine the day that to sign your name is a burden, to witness several documents, whereas we see as we get older and as we become more frail, as we go further into an illness, these very basic things that we take so for granted, our mobility, get further and further compromised. So when you're healthy and young and competent, don't take it for granted. Get the things done that not going to be near as easy as the years go by.
Boy, you're not kidding. And it's very difficult. And I'm listening to you, and then I can visualize young couples starting their family. And believe it or not, that is when you should be thinking about a trust.
Yeah.
Because if one of the family that's the breadwinner is incapacitated and passes on for some reason, what's going to happen with the rest? Someone has to have a guideline for this is what we want our children to have if the parents are no longer around.
And Ron, I think it's a good idea maybe if we review all of our trusts, not just the living trust, but children's trusts set up by young parents who are just accumulating their assets, may not yet have a lot of equity in their home. They've just started their 401ks.
Right.
So they really feel, well, I may not have a lot yet. But insurance, when you are that young and healthy,
yes.
Even term insurance is so inexpensive. It's less than cable per month. Now suddenly you maybe have $750,000 or $1 million that you can plan for the possibility of one or both parents being gone.
Right.
I just saw recently in an insurance agent's wall, it said if every wife knew what widows know, they would all have more insurance. So simple insurance, very inexpensive for that young couple that you talk about. Then they can plan for their children's lives, guardianship, education, and talk again about peace of mind. Because when you become a parent and you have these very young, vulnerable, dependent children, it is a fear, what if? Now what if I'm not there? What if we're both not there? And planning through children's trusts and getting, funding those trusts with some insurance, it's just a terrific way to get to that peace of mind.
Good. Well, thank you, Eileen. This has been great. I'm sure we've triggered some thinking by the viewers. And for the viewers to identify her, Eileen Kerlin Walsh has an office in Worth, and we're going to put her address and phone number at the bottom of the screen. And I'd like to suggest that if you have a question, give Eileen a call. Give her office a call, and she can answer some questions that you may have, as well as maybe have you come into the office and
talk. Our viewers do, Ron. They do. They call me. They watch the show. They are getting information, and I get terrific feedback. So it's good to know we are reaching the very people in the community that you aim to serve.
Yeah. Well, thank you again. We will be back in a few weeks with another topic, and Eileen is really good about putting a package together for the show. Thank you again, Eileen.
Oh, thank you, Ron.
See you in a few weeks. See you viewers in a few weeks. Stay with us. You'll see us in 3 weeks to a month with a new show.